So why don't I kick us off? Hello, everyone. Thank you so much for joining us for this celebration today of the new book that's just come out from Amy and Tom. I have actually a copy here in my hot little hands. I was reading it online until Amy was kind enough to send me a paper copy. So it's already dog-eared. I'm already taking lots of notes. I realized I don't know that much about arbitration now that I'm reading this book, but there's so much more to learn. But this is going to be a wonderful discussion and conversation with our authors today. Thank you for joining. And I know we're going to have a lot of people that are joining in over the next few minutes. But let me just start out, and I'm going to make Amy do this for Tom in a minute. But I want to start out talking about Amy Schmitz, because I think Amy, especially in the online dispute resolution area of the field that I'm in, I think Amy is the preeminent global academic who is leading the work and the theory behind the field of online dispute resolution. Now, the amazing thing to me is not only is she doing this in online dispute resolution, she's also leading dispute resolution more generally. And I don't know when you find the time to do this work, Amy, because I've got you working 24/7. So I don't know how you find more time in the day. But Amy is the coiner of the term OARB, which is online arbitration, which I was delighted to see there's a big section on in this book. I can wax poetic about how great Amy is as a co-author because we've written articles together. We wrote a book together. So Tom, I know I often say it's like getting paired with the smartest girl in biology lab. Like, you're going to get an A because she's going to do an incredible job. And it's like victory, a big win. But
just make sure she's on your team, right?
Yes, exactly. Exactly. Make sure she's on your team. But I just want to say, Amy, not only from me, also from Neil, from everyone in the online dispute resolution field, how much we value your contributions at arbitrate.com, your contributions to the field. And one of the reasons why we wanted to do a celebration of this book is because, you have played a crucial role in this whole process. And I can see, I know what your voice sounds like. So I read a lot of your voice in this book. So let me just start out with an appreciation of Amy. And I'm sure others have other things they'd like to say as well, including Tom. But Amy, I know you have similar things that you could say about Tom. So maybe I'll hand it to you after I've laid it on pretty thick.
No, now I'm like super embarrassed because it's just not true, and you shouldn't lie.
It's not. Everything I said is 100% true. Everything
I really wanted to celebrate Tom and thank him for including me, because this is really building on his work. And I will tell you, I just have a little story because it's kind of fun in the sense that back before I was even going to teach, and I was thinking, I'd really like to teach. And I was at the law firm in Seattle practicing law and happy as, practicing law. But I thought, gosh, it'd be my dream. I want to make a difference. I would love to teach. Gosh, wouldn't it be cool to do arbitration and teach arbitration? Because that's what I was essentially doing in practice. And the first person I called, literally cold called. I mean, he must have thought I was the weirdest person ever, because I just called him. I sent him an email, I think, first. But I reached out to Tom Stipanowich because I knew that he was the guy in arbitration with everything he had done. And so I immediately reached out to Tom to get his advice and thought and counsel. And that's been true like throughout my career. I mean, I can reach out to Tom at any point and ask his thoughts on things. And I just am so thankful for that. And this whole thing came about because Tom asked me to join the crew on the Resolving Disputes book. And so I felt so blessed and honored because it's this amazing book with this history and background and very well respected in the field. And to just be even included in the same sentence with Tom Stipanowich was really exciting and really amazing. So I'm just so thankful to Tom. I mean, we had there was a big conference on engaging the futures of ADR. And right away I thought, if there were like an ADR prom, Tom would be the king, right? Like he's the guy. And so I just really appreciated him inviting me to join the Resolving Disputes book. And really a lot of this book, there's a lot there that was from the original Resolving Disputes book. And this is a first edition because it's the first time that we're actually making it a standalone split. So that's really exciting to be part of that. But I just want to acknowledge that it's really Tom who started this whole thing. And it was originally Tom who was leading the way with this book. And then it was really fun to get this opportunity to kind of develop it into its own standalone book and to work with Tom in that process. So I'm just super thankful for all the work that Tom has done in the industry and in arbitration. And I appreciated his perspective because I had taught arbitration using more doctrinal books for many years. I used different books that were just all case law, right? Like, so it involved a lot of, which is great. And I love the law part of it as well. But what is special, I think, about this approach is to focus on practice as well as law. We include in the teaching materials, we have lots of PowerPoints and exercises, and we're still building that actually. I mean, just yesterday I was sharing with Tom one of the exercises that I do, and he's sharing with me, and we're adding it to the teaching manual. And then, of course, Colin, you have been so important in allowing. No, the aspect from the,
but
but the videos. The
we
video.
have to, okay, we're going to get into all of this. That's what the conversation is about today.
All
But
right,
Tom,
so
I want to give you an opportunity now that we've bragged on Amy and bragged on you. I don't know who you're going to brag on, but we have all these great leaders here on the call. I mean, this is like the Hall of Fame here. We've got Rich Chernick, we've got Sarah, we've got John Allen, we've got Jim. I mean, so you know, you're a leading light. I think he has some competitors for the prom king of arbitration on this call. So
no question. Let me just say that I'm humbled to see so many friends and respected colleagues from the field on this call. This has been a labor of love. Not that, but just like with children, there are days and nights when you really don't want to think about it. But I couldn't have a better companion on this journey than Amy. And to me, it really is a new day in terms of the whole project. We'll talk later about the book and some of the details. Let me just say that Amy is remarkable. I don't know anybody like Amy. We immediately felt an affinity. Amy, this is long ago history now for me, but we both began our careers as lawyers specializing in complex construction cases. And that's kind of a laboratory for the use of arbitration, and beginning in the 90s, rapid growth of mediation and a lot of other approaches, including standing dispute boards and other approaches. So Amy and I had a lot to talk about. I really felt an affinity with her, but I've always liked the heck out of her. And she's one of the hardest working, most dedicated and insightful people in our field. I sometimes worry about Amy because I don't know when she sleeps. And one of the things that I think is so remarkable about the project now is that we have over 100 interviews that on video that Amy has done. And, like Dwight Golan, who has really taken the lead along with a number of other people in producing phenomenal videos on exercises and other things. Now we've got Amy, who's done all this. I mean, this is unprecedented to have all this material from practitioners and academics, a lot of different perspectives on where arbitration is and is going. And I think it's really humbling again to see all that she's brought to this project. But I'm happy that Amy is with our friends at Ohio State. I know she was a leading light at Missouri for a number of years, and I'm just grateful to have the opportunity to work with her on any project, and it could be on any topic. But anyway, we're thankful all of you are here, and I know you're interested in hearing about the book. So, Colin, I'll stop there, and we can move forward.
Absolutely. And look, a big point of this call is the love fest. So let's just let the appreciation and love wash over us, Amy. Don't resist it, just accept it. But I will say, many of the people who have been interviewed on Arbitration Conversation are here. And, one of the things that I've realized at Mediate now that we've been doing this for 27 years is some of the people we interviewed aren't with us anymore. And that is an important archive of their
Mhm.
expertise in the field. So I agree. This is an incredible contribution that Amy has made, not just 100 now. Now we've done, another 15 or so podcasts. So please, we need to revisit. I want to hear what Ben has to say. I want to hear Nancy. I want to hear Jan. So, Tom, I think you were one of the first ones we did. So maybe we need to do. And if you haven't done an arbitration conversation, let Amy and me know, because everybody on the call, these are the folks. All right. Let's first of all, I want to open the floor, because this is going to be an open conversation for all of us. This is clearly not a presentation style hour. As I said, we have many of the leading lights of dispute resolution and arbitration education on the call with us. And many of the folks on the call have been involved with this evolving document, that is turned into the book. So maybe we can start there, because I do know there's sort of a long and winding path to get to the point of having this published and in my hands. I mean, I think, Tom, you had some of these chapters. How long have they been circulated and used in classes? I mean,
well, we're actually on the 4th edition now of the main volume, which contains material which is not identical to what we have in here, but does cover a lot of the same territory. This is a longer version, and of course, significantly updated from the last one, which was back in 2016. This thing started with Jay Fulberg and Dwight Golan, two wonderful, wonderful folks. And I got wind of this, actually, the project. They were working on a book that they wanted to make very practice-oriented. And Dwight, of course, had all these great materials. Jay had been engaged heavily on the training side, along with all his other educational and scholarly pursuits. And it was really a meeting of the minds about what a book might look like. And I found it a particular challenge to try to develop materials for arbitration that would be in parallel with all these wonderful materials that had been developed with respect to negotiation and mediation. And when I came to Pepperdine, of course, this is sort of a mecca for training, particularly when it comes to mediation. And I said to myself, is there any way that I could make arbitration materials as meaningful and engaging in a real life sense, and fun, if possible, to people who, students and others who are in an ADR class or have had a series of classes, and they come away from this high after having taken a mediation class or a negotiation class. And I think there's a phenomenon some of us have experienced, that when you get to arbitration, there's sort of a letdown. And so I was really trying, among other things, to deal with that, but also to come at it from the point of view of practice. There's more that could be said, but that is really, from my point of view, the genesis of the book. I think it's important to emphasize, though, that I felt strongly the need for several years for a new pair of eyes and hands, and a mind that was really focused on a lot of the cutting edge issues. And Amy really over the last few years has done more on cutting edge issues than anybody I know. All the consumer stuff, including a lot of very useful empirical work that she did, that I thought was very, very useful. And now, of course, joining you, Colin, as one of the leaders in the ODR area. And so, plus, I just know Amy has really great insights, and having now more than ever, having talked to so many people in the field, I don't think anybody has more in her head in terms of what's going on and what's important. So I think this is really, this is a transformational time for the book. And this is the first time it's ever been published as a book. So we're really, I think for a variety of reasons, it's going to be different.
Well, I want to touch on one thing you said, which is, I think you're right. I think media and negotiation trainings in law schools are often some of the most popular classes because there's a lot of simulations, there's a lot of cases, and oftentimes they're taught as an intensive. But I have to say, I have been part of some arbitration trainings that were pretty dry. It's a lot of just, okay, here's another case. Now that said, I've also been part of some arbitration trainings that were incredibly dynamic. I think about Ben. Ben did a training on online arbitration for Corsica in Cairo that I was able to sit all the way through. Wow, it was so engaging. It brought it to life. There was simulations, putting people in the seat actually, and I was like, wow, this really, it changed my perception of what an arbitration course could be. It could be as engaging and exciting as a mediation training. So I love that that's what that was one of your goals, Tom, was to try and make arbitration education a little more dynamic like that. I'm sure everybody in here is an experienced trainer as well. So, but Amy, what do you think about everything Tom said?
Oh yeah, I mean, that's what I love is it starts with practice. It's not just jumping right into the law. And Tom has had really neat different exercises he has done over time. It's fun working together, sort of trading exercises, thinking about different things we can do, showing the difference between mediation and arbitration right in the beginning with, there's an exercise I do, the Senate table exercise, where you have the students first taking the same facts and using it as a mediation and then having to switch their hat to an arbitration. And when students are actually experiencing that, it's a good kind of entree into the difference between mediation and arbitration, but it's more active, and students really get into it. And so trying to think of it that way instead of just being doctrinal, because as Tom said, yeah, I mean, otherwise, if you've had a great mediation class and then you take arbitration, you're like, wait, I just stepped into contracts and constitutional and statutory and I'm bored out of my mind, right? And so trying to include all of the law, but then still make it interactive. So Tom had really neat exercises to begin with respect to the arbitration game that he'll explain. And also, of course,
I want to come back because I think
drafting.
That's going to be a great dialogue for all of us to talk about, because you were sharing some exercises with me. Actually, Jan was the first person I saw that ever did that. I mean, she has what's the exercise, Jan, over the desk?
Antique desk. Yeah.
I mean, I think it's exactly as Amy said. I've seen you use that very effectively to illustrate how this is part of a spectrum. I don't know if you want to speak to that.
Well, I think from just the last couple comments, arbitration is really distinct in that negotiation and mediation, the pedagogy comes from experiential learning, and the ABA has parked all the experiential classes under an umbrella, whereas arbitration, at least at Stanford, is taught as a doctrinal class. So they have a very different tone, a different expectation, a different pedagogy in how, and it's not that they have to be that way, but they have historically been more distinct in terms of how you teach, what the goal in teaching is, that people master the law, and then we weave in some practice to make it more interesting. But I think to step back, as Tom and Amy have done, and say, what is the whole that we want to accomplish with this book and with our classes? Because for me, arbitration is a distinct part of system design. It's one of the options, and you really, it's important to make that available to our students.
I agree with you, Jan. I think one of the things that's interesting in the field is we've sort of come up with kind of camps. Like being at mediate.com, I feel like there's a lot of mediators. You say arbitration and they're like, oh, I don't want to talk about that. Like, nope. And then I think, negotiation too, the negotiation side, sometimes when you get in the mediation field, they're like, well, I'm a negotiation person. I'm not but for me, it's a spectrum, right? And that's what I think your book does so well, is it talks about dispute systems design. We have to be able to paint from all of these colors. If we say we're only going to paint, we're going to use blue and purple, I mean, that's not nearly as rich as understanding the full spectrum. And I think in the ODR field, we're trying to embrace the evaluative side. Like if you only focus on the facilitative side, you're missing out on, a lot of the, so I think, your work, I mean, I don't want to start waxing poetic about how amazing that book is, but it really does emphasize arbitration is part of a palette.
Yeah.
Yeah.
So.
Well, in Jan's, I mean, the system design, we actually, I think it helps. This book is positioned as how can we think about arbitration as a problem-solving tool in the toolbox. And
Yeah.
I think a lot of that, Tom really elaborates because he's been the person on mixing and matching. So we have a
Yeah,
chapter
mixed mode.
devoted to mixed
Yeah.
mode. And I think it's important to kind of think about how arbitration fits into mixed mode. I don't know if you wanted to speak to that at all,
Well,
Tom.
I actually wanted to just talk about the structure of the book. What's the plan of the book? Who is the audience of the book? Why is it structured the way that it's structured? Who do you, when you were writing this book, who were you thinking about putting it in the hands of? I think, and you could talk about mixed mode in that context, Tom, but please.
Oh, Amy, I'll just briefly comment. My original intent in developing the book was, or these chapters, I should say, was first of all to dispel the sense that arbitration is one thing, and that all arbitration somehow falls within a very narrow category of possibilities. And so the first chapter is really offering a big picture, which places arbitration in the spectrum of possibilities, looks at history, its applications, particularly in the United States. But then we look at a series of scenarios involving different kinds of arbitration, including, standard commercial arbitration, labor arbitration, international arbitration, sports arbitration, like the Court of Arbitration for Sport, the Writers Guild arbitration, court-connected arbitration, and then try to encourage people about why these processes have developed in such different ways, what they have in common, but what they're different. So that first step is kind of a mind-expanding step to say, look at all the possibilities in arbitration. Then for the next 2 or 3 chapters, the emphasis is on the practice of arbitration, the real key how-to issues that are going to come up, taking basically a chronological approach, looking at arbitration agreements, where they fit in a contract, what the kinds of possibilities you have for drafting, key drafting issues, problems that can emerge, nightmare scenarios, and then selection of arbitrators is another chapter. And then we have a long chapter on process issues, taking people from start to finish in arbitration. Only then do we get to the law of arbitration. And now it was a challenge to try to figure out how to do that. And Amy and I, in the latest edition, have integrated more of the legal issues earlier because we want to make sure everybody is clear as to possible implications at different stages of the process from a practice point of view. So we have cross references and that kind of thing. But then the law comes into play, and we have tried to carefully delineate distinctions between just standard arbitration doctrine, meaning, with a commercial background, et cetera, or in the labor arena, and then this stuff that's evolved over the last 20 or 30 years in the consumer and employment area in the context of adhesion contracts. And so that is the last segment, actually a couple of chapters dealing with those issues. Then at the end, we actually have a couple of chapters. Amy, maybe you want to talk about that. I'll stop, but that kind of step back and take an even bigger picture.
Yeah. And I would add, and that was a really good delineation, and absolutely that really comes from Tom and the original thoughts on the book. And the piece I would add that's really new is kind of really thinking about technology from the very beginning of the book. So even when we talk about the different types of arbitration, we include the UDRP and domain name dispute resolution, which is a non-binding arbitration program, and other ways that technology has really changed the way that arbitration works, and how technology, when we get into practice, thinking about arbitration when it's online? How does Section 7 of the Federal Arbitration Act, for example, apply when you have an online arbitration? And what new sorts of issues are raised by OARB and online arbitration? So I think another thing that's kind of special about this book, as opposed to sort of traditional arbitration books, is that we do consider technology from front to end, which brings me to what Tom was intimating about the end of the book. So a chapter on mixed mode and mixing and matching, which is really, Tom is really, he was on the forefront of the switching lanes and switching hats, and this idea of really thinking about arbitration as just one tool in the toolbox and how it can be mixed with mediation and other modes. And conflict prevention, I think along the way, the other piece that is important with this book is really I've benefited from those interviews and learning about a lot of the different issues, but also, you know, including guest speakers like Natasha Richardson, who's here. We had a really wonderful speaker from Alterity talk about different things that happen in a hearing and good tips and tricks and making sense out of being a good practitioner in arbitration. We try to teach students through the book not only about the law of arbitration and practice from an arbitrator's perspective, but also what if you're representing parties in arbitration, because that's what most students are going to go out and do. That's what I did. I went into a quote unquote business litigation group and all I did was arbitration, which is very normal for a lot of law students. And so really getting tips and thinking about it practically and working with the rules. The book really requires the students to constantly be referencing, working with AAA, JAM, CPR, looking at the arbitration rules themselves. And then at the very end, we do dedicate, the last chapter includes a specific section on online dispute resolution specifically, and also system design. So Jan's work in building on thinking about where arbitration fits in system design, and we actually have a section dedicated to it. And we even have a part talking about social activism and thinking about activism and thinking about arbitration, and certainly policy. We include policy in the title of the book because we do discuss policy throughout the book.
Well, the other thing you talked about is the changing jurisprudence around arbitration. I mean, you know, we just did an event at Arbitrate, a month or two ago, talking about these 5 new cases, and now it looks like the CFPB is about to aggressively go after banning these pre-dispute binding arbitration clauses again. So, you know, it's a moving target. So that's the thing too, Tom. I mean, you mentioned as well, you know, you have to write this book again and again and again, because it's not like it's one thing. I will say, I also really, I mean, one of the things when I teach ODR, I don't talk about arbitration. I don't talk about OARB as much. I talk about evaluation, because what we're seeing is a lot of private evaluative processes that look like arbitration, kind of like the UDRP, but they're not enforceable under the New York Convention. You know, they're privately administered processes that follow a lot of the procedural guidelines that arbitration has long embraced. But I think this also gets to, Tom, you know, what you've talked about, how arbitration is the new litigation. And I think a lot of people are steering away from arbitration. We're seeing a growth of evaluative mediation because, you know, the procedure is getting a little onerous. So again, it's a moving target. So I think that's why it's great that, oh, you got the present that I sent you, Tom. No, I'm just kidding.
Sorry.
But I am eager to hear from others on the call too. I mean, I want to open up the discussion. But the other side of the question that you didn't answer is, who were you picturing that you were writing this for? I mean, Amy, you did say it's not just for people that want to be arbitrators. It's also for young lawyers who are going to be representing parties in arbitration. So that's important. But, you know, you have a lot of the top arbitration teachers in the world on this call. I mean, were you picturing that this would be a book they could use front to back in their courses? I mean, what were your thoughts there?
Yes, we hope so. I mean, and I think there's also the reality. It's not so one thing that is absolutely true in teaching arbitration and having used a lot of different books over the years, personally, first Colorado teaching arbitration for 16.5 years, then at Missouri, now at Ohio State. And there's a lot of different books out there. And one thing is for sure, every arbitration teacher supplements the book with other pieces. You know, we spent a whole class period on diversity in arbitration and had additional readings. And it is expected that you have ability to kind of use the parts, the book is great because it really does march you through front to back, and we include in the teacher's manual a lot more. So of course, in the teacher's manual, that is available because it's a connected case book for Aspen. So once you get access. And I have a whole bunch of codes, by the way, that they gave me and I can give out. So if anybody wants a code, I have one. So
I
you have
got those
free
too. I'll
access.
put, yeah,
Oh,
I'll put them
okay.
in the chat. Should I put them in the chat?
Sure. Why not?
It'll be a bit of a
And
feeding frenzy.
yeah, I know. Grab
you
a
know, because there's
code.
only so many, but yeah.
And we're still building the teacher's manual, but I think, you see a lot more, different cases, the cutting edge cases. Like we literally have been updating it with all the new Supreme Court opinions, adding new exercises. So I think, there's a lot there for anyone, but I think it's very usable, because the other thing that does happen with a lot of arbitration books is they're so huge and they've got so many cases that it's impossible to cover it all. And so what we've tried to do is, in the actual book, you could have a 2 credit or a 3 credit, and then you can supplement with additional readings and things that you'd like. You don't have to, though, especially as a 2 credit, you probably would just use the book. But if it's a 3 credit or a 4 credit class, you might want to add in some of these other ideas, and they're in the teacher's manual, right? And with all the new Supreme Court cases, you get a lot of fuel there, and there's lots of great ideas with respect to other materials, especially on policy. We had a brand new arbitration law that came up last year. So we include a note about FSASHA, and that was huge. I mean, that was the first time that the Federal Arbitration Act has been amended since the 1980s, when they added Section 16, and really the first significant amendment since 1925. So, it's a big deal, and there's a lot there. And so I think anyone who, with this book, it's very usable for someone who is an adjunct professor or somebody who has been teaching for 40 years and really wants to have a nice manual to use. And then it's a connected casebook, like I said, so you've got all this additional material that's available.
Great. Please, Ben, what do you want to say?
Well, first of all, I want to congratulate both Tom and Amy for this book. I've skimmed through it. I'm teaching arbitration right now remotely, so I'm in that online space. So if they have me teach again as this old fart, so to speak, it's certainly with something that I'd be using in a future class, because I think that one of the things that I really like about the book is I've taught arbitration, a lot of years, and when I started out, I actually have I gave the students 2 required books. One was Thomas Carbonneau's book, and the other one was von Maren's book, because I wanted to have domestic and international in their one arbitration class, which seemed like a lot to pay for. But I said, well, you're getting all of this in one class as opposed to having to take 2 separate classes, And so one of the things that I really like about what I've seen in your book is that I can just use this one book now for purposes of taking them through from domestic and the varieties that are there through to the international side. The other thing is, this is the first year that I've been learning that I'm supposed to be teaching arbitration experientially, Jan. And so I was like, oh, okay. So actually I kind of had to adjust somewhat, although I didn't realize I was adjusting. And so one of the things that I think is great with all these exercises is that for arbitration people who teach, quote, experiential arbitration classes, the exercises are a way to put the students in the roles of both counsel and arbitrators. So what I like to do is basically, when I start the arbitration classes, give them a fact pattern, and the class has to play the part of the claimant and then write what the claimant would write for whatever set of rules you want to pick. And then after they've done that, they all become the respondent receiving what they just wrote. And so now they have to respond to that. And then they move from there into being separated into claimants and respondents. And now they have to put together an arbitral tribunal made up of the students, right? Not somebody external or me as the sort of God sitting in the middle, right? And then there may be other roles for institutions and all that students play, but they get to play all the different roles in terms of the procedure and all that. And I think that's really helpful early on in these exercises that you have, that the students do this because they have no exposure really, or little exposure to arbitration in any of their other law school classes. It's all kind of focused in the courtroom. when we go through procedure, we get to the arbitral award, having the students deliberate the award out, in front of the other students. So you can hear the deliberation and see how they navigate if it's a tribunal. And then the interesting thing was that we got to enforcement, where I had to kind of put some law in with the FAA Chapter 2, Chapter 1, New York Convention. And then I said, so by the way, there's Ohio state law too, okay? But the fun thing was, I said, but what have I forgotten to talk to you about, right? And they're like, so I put up the page with the first page of the Federal Arbitration Act, and it says at the top, 1925. You know what I mean? And then I said, 97 years. A student says, case law. Yes, 97 years. And you see their heads kind of go, oh my, I mean, some students wrote in the chat, I gotta get a drink. You know what I mean? Because they're imagining 97 years of decisional law that's happening, that's underlying all of this sort of process. So that gets us over to the doctrinal side, right? So, it's kind of that mix of experiential and doctrinal, I think, that what you've really tried to do. And I would like to make a pitch for your Resolving Disputes book, which I am using in my ADR class. And we're just coming up on the end of negotiation. And the weaving together of skill sets and things like that, as well as problems for the students to work through. And I really like that you take on a lot of really interesting issues that can lead to discussions. I just happened, as luck would have it, we're in negotiation on identity yesterday. And so I had to sort of deal with the whole thing of race, gender, and culture in an afternoon. I solved it all, in case you want to know, okay. But but I thought it was really helpful, because one of the things to talk about is people are comfortable with people they know, is one of the sort of comments. And then the meditation was, well, what does that mean, right? In terms of people or people you're comfortable with, and the idea of opening the notion of what is your level of comfort kind of thing for students. So, I like the approach. I like the online part. That was another thing I used to have some frustration with offline versus online, experiential versus doctrinal, international versus domestic, and I like the fact that I feel, you're taking that on in trying to do it in one book, which is it's a daunting task, but I salute you for taking it on, because I think it really helps for us, as we're trying to figure out how to get these students up to speed when they're likely to have an arbitration before they'll ever be in court,
Ben, I think I remember attending your retirement party.
Yeah,
and you don't sound very retired to me. You're like teaching more than some full-time
I get these
prof.
calls, I say, hey man, can you do a gig? I'm like, oh, that's my wife.
Well,
yeah,
that's
your
great.
wife is probably getting mad at you, like, wait, weren't we going to travel?
Yeah.
Right. There you go. Fair enough.
That's right. Well, that's great. And I have seen Ben, as I said, do this firsthand, and it's incredibly valuable, incredibly sharp. I mean, the students are 100% engaged. So,
yeah.
But other thoughts. I mean, other people who've taught from the book or used it in classes. I think, I think it would be wonderful to hear some of that feedback.
I don't know that we have any folks on the call right now who have actually used it, but I know that our friend Carl Bayer was online right before we started today.
I'll share that because Carl was on. He's actually in the middle of a mediation, so he couldn't join the rest of the call. And he was one of the people I'm recording for. But he's used the book extensively, and he was just waxing poetic about how incredible it is and how excited he is about it. So one of the gifts you get as attending this event is you get a free copy of the book. So I put that in the chat. So use those codes, and then you can log in and get an e-copy if you want to check it out in terms of the structure of the book.
And I would love if anyone, Mike, John, anyone who's teaching or going to, like, things you're looking for in books, like things we should take into account for the next edition or the teacher's manual, or because I mean, we do have, it's kind of this gift that nowadays, we have this whole way to have a connected casebook, and we can include lots of additional stuff, and so I'd be curious to know what people are looking for who are teaching arbitration.
Yeah, I mean, one of the directions. Oh, please, Mike, did you want to say something?
Yeah, I was going to jump in. As Amy, I know knows, I teach arbitration at Iowa, have for the past 20 years, used many case books, used my own materials. And so I'm anxious to get a good look at this and to see, how this may apply. And I really like the focus, the sound of the focus of coming the genesis from a practitioner's point of view, yet directed towards law students. In terms of the practical aspect, the technology is, I think, huge. And one of the exercises that I've tried to do is to do an in-person arbitration simulation as well as a Zoom simulation, or to mix it in a two class scenario. So I think that's going to be very helpful. And you mentioned PowerPoints too, which I'm interested in seeing how those play out as well. So, I mean, all in all, I'm really liking everything I'm hearing, and I hope to be able to take a look at the book here in short order.
We'll definitely grab a code.
I'll do
Grab a
it.
code while you can. I think we have enough codes for everybody on the
Oh,
call.
I do too. I think we do. Yeah.
Yeah. But I think this also gets to one of the points. I mean, Mike raises this: is where is arbitration going? I will say at Mediate.com, we did a 6-month initiative, which was re-envisioning how we train mediators in the light of the expansion of technology, and now the fact that Zoom is the default for most mediations. And that creates whole new ethical dilemmas and whole new practice dilemmas. So, we had a bunch of different working groups talking about DEI and different aspects of mediation. I'm not aware of something that's happened in arbitration training or arbitration education. There might be something that's going on within the arbitral institutions. I know the Chartered Institute, they reshuffled their training quite a bit, thinking about the ramifications of technology. But again, I mean, the field is changing, arbitration is changing, it's evolving. So the way that we train arbitrators has to change and evolve as well. And that's not just case law, that's also thinking, what should arbitration be? I think Nancy was the head of the dispute resolution section when all of this pre-dispute binding arbitration stuff came out, and there was a whole argument within the field. I remember being in these meetings saying, well, shouldn't we speak out about this? I mean, shouldn't we be shaping where this is all headed? Like we're the ones who are thinking about the ethical dilemmas and, best practice standards. And, should we just allow these clauses to emerge and not speak up about it? So, I mean, in training, we shape where the field is going by setting these expectations. So, I mean, this is a great group to have a dialogue with that about. The book is doing that a little bit. It's not just reacting to the changes, it's also shaping the changes by this is the first exposure that a lot of law students will have to arbitration. And this will shape the way they think about it. So I don't know if people have opinions about that.
Can I ask a quick question, Colin?
Please.
So first of all, really glad to be part of this. I am honored to be in the presence of so many arbitration experts. And Tom and Amy, thanks so much for everything you've done over the years in connection with this. So John Allen Chalk and I have had conversations occasionally over the years about the need not just for law students to be learning more about arbitration and how to practice effectively within it, but also training and education for practicing lawyers who aren't necessarily perhaps aware of all of the ways in which they can affect productively how arbitration proceeds, both from a policy perspective and also from a very much a client-centered perspective. So I wonder whether there are some parts of this book that you might identify as perhaps being especially useful if we're thinking about practicing lawyers who need to be, they should be introduced to the law of arbitration, but also need to be introduced to the idea that they have responsibility, not just for learning how to adapt to whatever it is someone else is telling them to do, but also need to be thinking for themselves and for their clients about what this particular arbitration should look like.
I think Nancy, thank you for that. And also, I'm glad you mentioned John Allen, because he's here on the call, and if everyone may, I think he may have some familiarity with the book, although I know he also has his own materials. So maybe he'll want to comment. Let me just say quickly in response to that, to me, the first 4 chapters of the book are particularly focused on really trying to attune people to some of the key possibilities and also cautions about arbitration. To say again that arbitration doesn't have to be one particular thing. It can take many forms. And then of course you've got a lot of key issues relating to drafting and opportunities to reflect on what can go wrong. We have, among other things, we have an exercise called Drafting Nightmares, which is actually based on real life scenarios, a number of which I was dragged into after problems arose in different cases. And the fact is that there are these pitfalls that unwary drafters may find themselves falling into, and so we have all of that. And then we really tried to design it in a way that was aimed at the way practitioners would approach problems. And one of the reasons that I tried to we organized the book the way we did was I often feel like the emphasis on law, starting with law, to me is, I think it's a missed opportunity to get people to think about, what arbitration can be. Because people always say, well, arbitration is this or arbitration is that. And one thing I try to get people to think about is, well, it's like mediation. It may be very, very different things in different circumstances. And that really is the spirit of the book. I think we still can do more to achieve those goals and make it accessible. One thing that I want to mention one further thing, and that is that in the classes that I've taught in our master's program, we often have non-lawyers. And a lot of non-lawyers have been in classes where this book has been used. I think that when everything's fine, but then when you get to the legal stuff, it really does separate out the those who I think are serious, willing to do the work to try to get through all the density from those that aren't. But this whole issue of, well, what's the role of non-lawyers in arbitration? Is that a bygone era? When we talk about diversity, I think appropriately we focus on racial diversity, gender diversity, national diversity in international cases, or regional diversity. But I also wonder about professional diversity. And my own view is that, for better or worse, arbitration is much more law-oriented. And there are many reasons for that. And I've been probably part of that process over the years of questioning, why don't we have this or that in particular cases. But it is interesting. I tell the non-lawyers that unless they're specially situated, where they have a niche, or they might find themselves with opportunities to arbitrate, these days opportunities for non-lawyers are few and far between. And I find that in construction and commercial cases, it's fairly rare to have non-lawyers on a panel. We're all lawyers, and I, again, one can take different points of view about that. But in terms of changes over the years, I think that's something that we see. You pick up on this when you look at, for example, the language of remedy making under the AAA rules. And the references or lack of reference to the application of law as compared to CPR or JAMS. And I think there's some very interesting nuances here. Whether they make a difference in the individual case is a different thing. These are the sorts of things that we try to attune our students to in different. There's plenty of opportunity for Amy or me or any of us to really focus on different elements depending on our personal preferences and experiences. I'm sorry to go on so long, but John Allen, let me ask you before we continue, if Colin doesn't mind, do you have anything you want to add?
Well, I've used the third edition of the paperback twice, but in a master's class on arbitration, and it was the whole course had been drafted and processed and planned by Tom, and the book was incredibly helpful. And to me, as the teacher, it was a little harder, more difficult to get the students to enjoy it like I did. but the copy I have here is just incredibly marked up all through it. And I had resisted the hard copy Resolving Disputes big book, even though I had it as well. But I had taught law students at Pepperdine a number of times, and it was the experiential course, and I loved it because I could use my own manure, and we could do soup to nuts in the process.
That's right.
And I found students excited by the involvement they had in all the varying steps. So I never got this is a boring course at law school. I really didn't. Now in the master's program, it was difficult to really get the students to discipline themselves enough to overcome being in a totally virtual or online course. I think that's a special challenge as well.
Yeah, let me clarify that what John Allen is talking about is an online version of our courses, which require us to effectively can what we would be doing in, or at least elements of what we would be doing in a real life class. And I don't know that we need to go down that road, only because nearly all of you are using this not in such a fixed environment, but for someone like John Allen, I knew that was probably a frustration because you're tied into this particular format. But I'm glad to know that the book itself was of use.
It was
Tom, I have a little bit of a different perspective because I don't teach in law school anymore. I used the Chris Grahosel's book when I did, but I've been the primary trainer at JAMS for the last 20 years, teaching arbitration to brand new panelists. And we've gone from a sort of large classroom talking heads kind of programs to what is now entirely a role play exercise with Rich Burke helping me to create role play exercises. And it sounds to me like your new book would provide some interesting opportunities for integrating that into the program. Obviously, teaching brand new JAMS panelists arbitration when they are coming either from the bench or from a law practice where they thought they were pretty accomplished arbitrators is a bit of a challenge. But it really is valuable to sort of walk them through circumstances where they really might not have appreciated nuances of what you really need to do when you're primarily a commercial arbitrator at a place like JAMS.
Well, and Rich, I'm glad, I don't mean to interrupt, but just to reinforce what you said, let me first say that I've had the benefit of actually being in some of those trainings, including Rich himself presenting, and it's really the high end of the spectrum in terms of the level of detail and nuance. So Rich, I think, Richard, that we should talk more about opportunities to use in appropriate ways some of that material. If our material can be of benefit, of course, we want to do that. But Richard is, I think, something of a model for, he's something to aspire to. And the training that he does is in the same category, if you don't mind my saying that.
I always try to aspire to my alleged reputation.
I think Rich is one of the people that might be able to compete with you for arbitration prom king there.
Right,
Tom.
right,
You know,
right.
Richard is,
training new arbitrators is one thing, but trying to
He's-
train retired federal judges,
Oh, I know, that's gotta
like
be,
they're like, you don't need to train me anything. Let me train you. You know.
Yes.
That's right.
You know, when I first came to JAMS, I was very concerned about trying to become the manager of folks, most of whom were former judges and who all thought that they knew everything without ruffling any feathers and without being disrespectful of their varied experiences. But it has turned out that I almost never get any pushback from folks. They are always eager. The kinds of folks that we recruit are always eager to learn what they need to learn to be successful. And it's really been a great experience to participate in all of these trainings over, it's now more than 20 years with virtually everybody who is now at JAMS. And interestingly, after the training, the actual hands-on training, to be the quality control manager of the entire arbitration practice and to make sure that people who are no longer attending trainings are not getting themselves into situations or are helped in getting out of situations that presented bad choices that were made earlier on in a process.
Well,
I'm really concerned, guys, about how, in terms of what's happening to arbitration, in terms of the lack of encouragement by most arbitral institutions that I deal with, to encourage and realize the need for the initial and very early process discussion, and in order to tailor that particular arbitration and that particular dispute in a way that the dispute gets addressed efficiently or successfully. And most of the arbitral institutions that I deal with want little money spent up front by the arbitrator. They don't want billings and time being used to discuss process. And
it's interesting you say that, because that is actually the primary focus of the training is that if you get started on the right path, you are likely to end up at the right result. And if you don't, you won't.
And I would say this book, because I spend a lot of time on that in my class, and Natasha can also, because really getting students to focus and think about the preliminary hearing and designing the process and how important that is. And I think the book, by starting with practice and starting with that and looking at it in that way, I know that has been a huge focus of my class. And I hope that more arbitration teachers are taking time to really focus on that aspect. So, I mean, I have to say that is such an important aspect. And you know, I think also having the different interviews, and I require my students to watch them or listen to the podcast so they can learn on the run. But I think it's helpful because they hear from practitioners and they're learning how important designing a process is and how important that preliminary hearing is. So I'm really happy to hear all this.
Yeah,
One of the
please,
most revolutionary changes that I've seen in the 30 years that I've been arbitrating is that there are actually lawyers now who understand that and who are prepared to participate in a preliminary hearing in a way that is functional and sometimes self-initiated. I often get pre-hearing proposals from lawyers that look very much like my scheduling order number 1.
Mhm.
Well,
I
and
think-
the interesting thing is on the mediation side of the field, we talk a lot about fitting the forum to the fuss and Frank Sander and all of that. And Jan talks a lot about dispute systems design. Tom, that's one thing and takeaway I'm getting, and it seems like this is a big part of the book, arbitration systems design, you know, fitting the forum to the fuss, designing a process that works for the needs of each disputant. I think that thinking about arbitration as a thing, okay, well, it's an arbitration, so we know what an arbitration looks like. You're really limiting a lot of the creativity that I think can unleash the potential of arbitration.
And fitting the tech to the fuss. Even if you have an in-person arbitration, you might use technology to bring in different witnesses or for different aspects to manage the cost of the arbitration or testimony. So, I mean, there's so many different ways you can use design to really help both efficiency and fairness. Thank you. I just want to thank everyone so much.
I am aware of the time here. Yeah. So let's wrap it up. Amy and Tom, do you have any last comments you'd like to make before?
Thank you to Tom. Just thank you to Tom. No, but I really just want to thank Colin for doing this, first of all.
Yes. Thanks, Colin.
And thank Jan and everyone on the call.
All of you.
Everybody.
Yes.
And I'm so blessed to know you all. I mean, I feel like I have this whole family of ADR, ODR people, and it's really amazing. And thank you to Tom for just being a mentor from day one and sort of bringing me from construction law into teaching. And so I just really am thankful to have Tom as a mentor and friend.
Well, it all comes down, Amy, to relationships. I really believe that. We could be talking about widgets or, Hurricane Ian or whatever, but the fact that we have longstanding friendships and interchange, I have such respect for the people on this call. And Colin, thank you again for bringing us together. Amy, thank you for all you're doing, and every one of you in your contributions to our field. So I feel, again, as I said at the beginning, very humbled to see all of you and look forward to continuing conversations with a number of you. I think the best thing to end this by saying we welcome your suggestions, your good ideas, your input. We want this to be more effective for practitioners and for users of arbitration. So we know how busy you are, and thank you again.
Yeah, thank you.
Perfect place to end it. Thank you, everyone. Have a great day.
And thank you, Colin.
Be well. Enjoy
Thanks again.
your Cabernet, Rich. Okay. Take care, everyone.
Bye, guys. Thank you.
We'll see you soon.
Best wishes.
Bye.
Thanks so much. God
Bye-bye.
bless.